York. Welcome. My name is Yvonne Hennessy. I am a partner at Hiscock in Berkeley. I am co-chair of our oil and gas team as well as our environmental practice. And so today we're going to talk about aggregation of air emissions and what does adjacency really mean. As many of you know, this has become a huge issue for the oil and gas industry with case law developing with as recent as just a few weeks ago. So we're going to start out and walk you through the history of this issue, where we are today, and hopefully I'll have some answers for you by the end of this webinar. So sort of where we're going to go today, we're going to talk about what a major source is. I'm sure most of you are aware of. Give you a regulatory history of adjacency and how it's been interpreted by the EPA, et cetera, starting back in before 1980. Then spend some time talking about the summit decision out of the Sixth Circuit and how EPA reacted to that, as well as the recent decision out of a federal court in Washington, D.C. Governing how EPA was going to react to the summit decision. And then we're going to talk in depth about Pennsylvania and West Virginia, about how they're addressing aggregation. Touch briefly on New York. As most of you know, we're not drilling in New York right now. And then I've got a quick hypothetical just to show how complicated these issues are, which I'm sure many of you are aware. And then we're going to conclude with a current state of the law. So with that, let's get started. So major source. This clearly is the definition from the federal regs. The Clean Air Act defines a major source as any stationary facility or source of air pollutants that directly emits or even has the potential to emit 100 tons per year of any air pollutant, and these are just a quick summary of those. And then our permitting process for prevention of significant deterioration, new source review, Title V, all of those regs have these major source thresholds. And so when we're evaluating whether emissions should be aggregated, we're looking at issues in terms of adjacency, and so let me walk you through that. First, we start with what is the definition of a stationary source. Stationary source is defined under federal law, as you can see here on the screen, and then the states also have very similar definitions as to how they define them under their state law. So let's start with building, structure, facility, or installation, because that's the key definition here. And so the quote comes from the Federal Register, or the Code of Federal Regulations, and it's all of the pollutant-emitting activities, which, 1, belong to the same industrial grouping, 2, are located on one or more contiguous or adjacent properties, and 3, are under the control of the same person, or persons under common control. And so you'll see when we get to this analysis of aggregation, generally the permitting authorities look at 3 criteria, and it's broken down just like the regulation in terms of same industrial grouping, contiguous or adjacent properties, and you've noticed I've highlighted adjacent here because that's usually where the dispute arises, and 3, common control. Interestingly, we have no statutory definition or regulatory definition of what adjacent is, either at the federal level or at any of the states that we're going to talk about here. And that's sort of why it's become such a complicated and controversial issue. So the key issue, as I've said, is what does it mean to be adjacent? Should adjacency be determined based on geographic proximity alone so that you're not looking at any other factors? Should we use a strict functional relationship or operational interdependent test to determine whether sources should be considered adjacent? So there you're not looking just at are they a quarter mile, a mile apart. You're looking at what is the relationship between the facilities to decide if they're a single source. And third, is there actually a middle ground? Can we look at both geographic proximity and operational interdependence to decide if facilities are adjacent? And if we can, is that really what the Clean Air Act requires? So let's start with the regulatory history of adjacency. We go back to 1979 in the Alabama Power versus Cossell case, and that was a 1979 federal case out of the Federal Circuit. And there, the litigation concerned challenges to the EPA's final regulations when they were implementing the 1977 amendments to the Clean Air Act. And there, the court found that the EPA had defined stationary source inappropriately, and that they couldn't do so, and they couldn't define what was a stationary source any broader than the language of the Clean Air Act. So the definition can be broad enough to cover an entire plant, but it must comport with the, quote, common sense notion of a plant. And the EPA cannot aggregate sources that would not fit into the ordinary definition, and here's where we go back to the regulation and the statute of building, structure, facility, or installation. And so what did the court tell the EPA to do? The court said you need to go and you need to develop a regulatory structure or definition that use consideration such as proximity and ownership. And they also admonished the EPA that they needed to define these terms in a way that made the aggregation test predictable for the potentially regulated entities. So then the EPA went back and we had the 1980 rulemaking. And there the EPA confirmed that it did not intend for a single source to encompass activities occurring many miles apart along a long line of operations. And for example, the EPA would not aggregate all of the pumping stations along a multi-state pipeline into one source. And the EPA, as part of this rulemaking, declined to add the specific functionality criteria to the definition of a source. And it's interesting because why didn't they do so? They didn't because such assessments would be highly subjective and they would embroil the agency in fine-grained analysis, which is, as you know, perhaps is where we are now. And so the EPA really wanted to avoid a highly subjective test when it went through the 1980 rulemaking. But they didn't say how far apart activities must be in order to be treated separately. They didn't have a rule of thumb as to what would be too close or to be a single source or what would be too far that you wouldn't be considered adjacent or contiguous. So there was no bright line distance test. And instead, they decided to have case-by-case determinations. And so early on, the EPA continued with this idea of looking beyond geographic proximity. But we've had some leadership changes across the decades with the EPA, and over the years, their decisions started to aggregate sources that were miles apart, and they were considering them single sources for air permitting and regulatory purposes. And then in the 1990s, the EPA really started giving greater weight to this concept of functional interrelatedness of operations, and giving less weight to the physical separation of facilities. And what's interesting is we didn't have any change in the regulations at this time. We're still going past the rulemaking from 1980. There were no changes to these provisions in the Clean Air Act. And really, you are seeing this change in policy emerge through individual letter determinations. So in 2007, the EPA issued a guidance memo, Source Determinations for the Oil and Gas Industry. And its purpose was really to provide guidance to assist permitting authorities in making their stationary source determinations. And this memorandum relied heavily on Alabama Power, the 1979 case, in terms of what was the EPA's boundaries for defining and interpreting what was a stationary source. And interestingly, the guidance really recognized, the distinct nature of the oil and gas industry and how these determinations were not always straightforward, and really sought to simplify the analysis. So in the memorandum, the EPA concludes that given the diverse nature of the oil and gas activities, proximity, i.e. geographic proximity, is really the most informative factor when you're making a single source determination. And it sort of established this rule of thumb of a quarter of a mile, and they cite to guidance from other states where they were using a quarter of a mile. And so at the end of the day, in 2007 at least, it was geographic proximity that was supposed to be guiding permitting authorities and how they were making single source determinations. But then, in the fall of 2009, I remember it, September 2009 actually, the EPA came out and had a reversal. They issued a second memorandum where they withdrew the 2007 memo. And here you can see the quote from Gina McCarthy, who was the assistant administrator at that time. Noting that the 2007 memo didn't mandate application of a particular approach, but was a non-binding policy statement that set forth a possible methodology, so clearly trying to distance the importance of the 2007 memorandum. And basically in 2009, they rejected the emphasis on proximity. Gina McCarthy says, I find that individual facts warrant a closer examination of all three criteria identified in the regulations, so that's the SIC codes, the common control, and the adjacency, and that the simplified approach previously provided was not sufficient. You needed to go further. And the memo goes on to indicate that activities that are located more than just a short distance away could actually be aggregated and considered a single source depending on the specific facts. And so this is where we really see a formal policy guidance document endorsing functional relatedness in terms of determining adjacency. So what happens next? We get the Summit Petroleum Corporation case in 2012, and this was a big case when it came out in the Sixth Circuit. So Summit. Summit is a producer of natural gas, for those of you that don't know, and it owns and operates a natural gas sweetening plant in Michigan. This plant sweetens the sour gas from approximately 100 production wells by removing hydrogen sulfide so that the gas can be used. Summit owns all of the production wells and all of the subsurface pipelines that connect each of the wells to the sweetening plant. The wells themselves are located over an area of approximately 43 square miles at various distances from the plant, and they can be anywhere from 500 to 8 miles away. In addition, Summit doesn't own the property, however, between the individual well sites or the property between the wells and the plants. None of the well sites shared a common boundary with each other, nor did they share any common boundary with the production plant. Flares do work as part of the plant operations by burning off natural gas waste to relieve pressure on the natural gas collection equipment, and the closest flare is approximately 1/2 mile from the plant, and the remaining flares are over 1 mile away. Alone, the plant does not exceed any of the major source thresholds under the Clean Air Act. However, if aggravated with even just one of the wells, the plant would exceed thresholds. And this is just sort of a schematic showing you the area in question in the Summit case. So based on a request from Summit and the Michigan Department of Environmental Quality, the EPA determined that the plant and the wells should be aggregated because they were, quote, truly interrelated, and therefore they found the adjacent prong had been satisfied. They actually looked to the 2009 McCarthy memo to support their determination. Now, Summit went ahead and appealed EPA's decision challenging the use of functional relatedness. And this is where we get to the Sixth Circuit. And the Sixth Circuit overruled the EPA's determination. And it's a pretty stringent decision. Clearly, the court was not happy with what the EPA was doing. It's one of my favorite cases to go back and read that I reread again this morning because the court really takes issue with what EPA had done in this case and provides absolutely no deference for what they were doing. And so the court looks at the dictionary definition and the plain meaning of adjacent, and it determines first that the word adjacent, the definition of it, it's unambiguous. It requires proximity. The court also looked at case law to find more support that adjacency relates only to physical proximity. And then the court goes on to say that the EPA's functional interrelated test was really unreasonable, and it wasn't even supported by its own regulatory history. The court also looked to arguments that API had put forth in that case. APA had filed some amicus papers and agreed that the EPA's test had been particularly ill-suited for this industry and that it didn't comport with the common sense notion of a plant, which is what the court required in Alabama Power. The court also agreed that this common sense notion of a plant dictate from Alabama Power was meant to constrain, not enlarge, the EPA's definition of what a single stationary source is. Now here, the court didn't actually find that the facility couldn't be aggregated, but it remanded it back to the EPA and ordered it to make its single source determination based on the requirement that the sources be aggregated only if they were located on physically contiguous or adjacent properties. The court, as I said, didn't say how geographically close would be sufficient, but they did remand it back to the permitting authority, and one judge dissented in that case. And here is just a quote from the decision that I like so much, and it's in response to some of the API's comments that were filed in the case. And I've highlighted in blue sort of why the court was so upset here, and the fact that this took 5 years for a decision to be made, 25 conference calls, a small mountain of papers. And then the court goes back to what EPA had said they were trying to do in 1980, which was to avoid that fine-grained analysis and administrative burdensome. And so the court really saw Summit as the epitome of what was to be avoided back in 1979, 1980. And so this is just a quote from the case. So how did the EPA respond to Summit? Well, as many as you know, first the EPA sought to have rehearing by the Sixth Circuit, which the court denied in October of 2012. And so following that denial, the EPA decided to issue their summit directive. And basically, they went after this policy of non-acquiescence, where they said, well, okay, we have to follow the court's decision in summit inside of the Sixth Circuit. So Ohio, Kentucky, Tennessee, and Michigan. But anywhere else in the country, we are not going to follow the summit decision, and we are going to continue to apply our case-by-case determination where we look at functional interrelatedness. Well, that was challenged as well. The National Environmental Development Association's Clean Air Project went to the Court of Appeals for the D.C. Circuit in Washington, D.C., and basically challenged the summit directive. I've listed here some of the members of NEDA. And what were they arguing in that case? Well, NEDA basically said, and this didn't really go to the merits per se of summit and whether or not summit reached a proper decision in deciding the adjacency question. But what NEDA argued was that the EPA had violated the Clean Air Act in its own regulations because by issuing its summit directive, it established inconsistent permitting criteria for facilities for those that were in the Sixth Circuit versus those everywhere else, like in Pennsylvania, West Virginia, et cetera. And the EPA opposed. They argued a number of things in the beginning. For example, they said first, NEDA doesn't even have standing to bring this challenge. They're not a proper party to challenge this in court. They also argued that the summit directive was really not a final agency action and therefore couldn't be reviewed by the court. Also that it wasn't right because there had been no adverse effect on any of the members of NEDA. And then finally, that under the Clean Air Act and the Administrative Procedure Act, the EPA wasn't even required to adopt the summit decision on a nationwide basis. Well, we just got a decision a few weeks ago where the D.C. Circuit disagreed completely with the EPA, rejected and invalidated the summit directive. So for the first couple of issues, in terms of standing, the court noted that all of the members in NEDA included companies in the oil and gas industry as well as others in manufacturing sectors that operate facilities regulated under the Clean Air Act. And because a number of those members had facilities outside of the Sixth Circuit, they remain subject to the EPA's functionally interrelated standard. Thus, the summit directive put those companies at a competitive disadvantage. The EPA had argued that those claims of competitive disadvantages were speculative, but the court didn't agree with that as well. So it found, one, that they had standing to bring the challenge. As to whether or not it was a final agency action, the court said, no, it's not merely a policy statement or an interpretive rule. The record establishes that the summit directive provides firm guidance to enforcement officials as to how to handle permitting decision. It was therefore reflected a settled agency position that had legal consequences. And in making that determination, the court did look to a recent decision where the summit directive was relied on in North Dakota to find that, yes, this was having implications and it was final agency action. The court also found that the case was ripe. There was something that the court could decide. They didn't need to wait for the summit directive to actually be applied. So then let's get to the substance of the claim and the merits in terms of whether or not the EPA violated its own regulations with the directive. And I just want to quote the regulations here, the regional consistency regulations, and they're found in 40 CFR section 56.3, where it notes that it's EPA's policy to assure fair and uniform application by all regional offices of the criteria, procedures, and policies employed in implementing and enforcing the Act, and also that it provide mechanisms for identifying and correcting inconsistencies by standardizing criteria, procedures, and policies being employed by regional office employees in implementing and enforcing the Act. So the court found that the summit directive was plainly contrary to these regulations, which require national uniformity. They also rejected the EPA's argument that the agency had no choice but to acquiesce across the country and follow the Sixth Circuit directive nationwide. The court didn't really buy that argument that they were bound to take this position or else just acquiesce. The court said, you know, there were a few things you could have done. You could have appealed to or sought hearing in front of the United States Supreme Court and see if you could have gotten that court to take the case, and you didn't. You also could have tried to revise your own regulations. A couple of ways you could have done that. One, you could have revised your regulations in terms of how do you make the single source determination, and you could have put in this functional relatedness concept into the criteria for determining aggregation. You didn't do that. You also could have changed your regulations in terms of regional consistency to allow for the EPA to non-acquiesce when you reach you have a judicial determination in one circuit that you don't agree with nationwide. That you didn't do. So it's your own fault that you actually here need to comply with Summit nationwide. So as for the substance of the Summit decision, I note here the court never addressed whether or not it was properly decided. It doesn't reach the question of whether or not the Sixth Circuit got it right, that geographic proximity is the key factor. So what are the next steps? As of yesterday, the EPA has not sought either rehearing in the D.C. Circuit. They still have time to do that. They can try to get an en banc hearing where the whole court would hear the case. They also could seek petition for a writ in front of the Supreme Court. They haven't done that yet that we've seen. And then finally, as the court noted, they could amend their regulations. They could amend their Clean Air Act regulations to replace the adjacency requirement with functional interdependence. They could revise their regional consistency regulations to allow regional variances created by judicial decisions. So we'll need to wait and see what the EPA does. The timing for rehearing or a writ of certiorari or a filing a petition for writ will expire very soon. The regulations obviously would be more time. I'm not sure a regulations changing the adjacency requirement would go forward without much legal challenge, and even if they would be upheld, but it would be interesting to see where the EPA decides to go from here. And of course, we'll try to post updates as they come down. But what is NETA's impact right now? Well, pending any further action by the EPA. As for right now, the EPA is halted in its efforts to apply functional interdependence rather than the plain language approach that we found in the Summit decision. However, states implementing the relevant Clean Air Act programs are not directly affected by this NETA decision at all. It really controls EPA's actions in terms of how they interpret their regulations consistently. But it will impact their ability to compel states to use the preferred interpretation that the EPA has of functional relatedness. So moving on to the states in terms of how they're addressing aggregation, and Pennsylvania clearly has a significant amount of history on this issue, so I'm going to spend quite some time on them, and then we'll move into West Virginia and then quickly cover New York. So Pennsylvania, as most of you know, in 2012, they had a final guidance document for how they were going to do single stationary source determinations for the oil and gas industries. This is just a few quotes from the press release when the guidance came out in terms of what PADEP thought of their guidance documents and its following the Summit Petroleum, etc. And really, under Pennsylvania, geographic proximity is the key factor. I wouldn't say it makes geographic proximity the only factor, but the plain meaning of the terms contiguous and adjacent should be the dispositive factor when determining whether or not stationary sources are contiguous or adjacent. And so here are the two definitions that they use in the guidance document for both of those terms. And if sources are less than a quarter of a mile away, they're presumed to be a single source. This is sort of the rule of thumb that Pennsylvania DEP adopts. Anything greater than a quarter of a mile distance, you have this case-by-case analysis. Not surprisingly, at the time the guidance came out, EPA provided negative comments on the Pennsylvania guidance. And there was threatened enforcement, but nothing has ever come of that. One of the first Environmental Hearing Board cases to address this issue in Pennsylvania was Lower Mountain Midstream. This was an appeal brought by the Group Against Smog and Pollution. The DEP had determined that the emissions from Lower Mountain Shamrock Compressor Station should not be aggregated with emissions from a nearby well pad. And so they challenged this decision not to aggregate emissions. There were a number of filings in front of the Pennsylvania Environmental Hearing Board. There was a motion for summary judgment that was denied because there were some factual issues regarding common control, et cetera, as well as distance from facilities and possibly the issue of functional interrelationship. However, the appeal was withdrawn in April of 2013. GASP said they were no longer interested in pursuing the appeal, that it would no longer be productive. I can tell you there was a discussion of whether or not evidence of functional relationship would be admissible if they had ever have a hearing and it was fully briefed, but there was no decision from the Environmental Hearing Board as part of this case. But then we get to Mark West. Mark West is a 2011 case. There, the DEP had determined that a processing plant and several compressor stations that were anywhere from about 1.5 to 11 miles from the processing plant, they were not a single source based on DEP's analysis, and there was no aggregation. So the Clean Air Council appealed DEP's decision, and they basically argued that the sources needed to be aggregated. And this is just sort of a map. You can see the little red triangles are the compressor stations, and the what looks like a little sun is the gas plant to sort of show you the distances. And so during this proceeding in front of the Environmental Hearing Board, Mark West had filed a motion to preclude evidence that the Clean Air Council wanted to introduce regarding the functional relationship between the plant and the compressor stations. And so the real question for the Environmental Hearing Board was whether or not the facilities could be considered adjacent based on their functional relationship, or whether the inquiry was limited to geographical proximity. And this is an interesting case because the hearing board actually had oral argument on a motion, which it almost never does, and they did it en banc, so it was everybody listening to it. And ultimately, they denied the motion to preclude evidence. And basically, it's decided that evidence of a functional relationship could be presented by the Clean Air Council at the hearing. And as part of that hearing, the Environmental Hearing Board would determine how much weight the functional relationship should be given in determining whether or not these facilities were adjacent. But we never got that far, and there was a settlement in that case last fall in September, and the hearing board closed the case. So there's been no appeal to the permit, et cetera. Interestingly, the Clean Air Act Council, one of the other aggregation cases in New York is the Sunoco case. And that case is a little bit different. There was a decision to aggregate facilities, and it was the facilities that were 18 miles apart, 2 refineries. And there was a decision by the regulators, and I'm pretty sure the application itself conceded that they were aggregated. And there, the Clean Air Act Council actually challenged the decision to aggregate those facilities. But interestingly, they withdrew that litigation, and there was a settlement. So what appears to have been an inconsistent position on the Clean Air Act Council has gone away. So let me get on to Penn Future. This is the what I would say is probably one of the more important cases where we're awaiting decision in Pennsylvania. This is actually in court. It's in a federal court in the Middle District of Pennsylvania, where Penn Future has sued Ultra Resources. But interestingly, the DEP is not a party at all in this case. So what's the background in this case? Ultra Resources operates some natural gas wells. They've got 13 producing well pads in Potter and Tioga counties, Pennsylvania. When compression became necessary, Ultra went ahead and obtained approval from the DEP to construct, and they actually did subsequently construct 8 separate compressor stations on certain of the well pads. Gas from each of those wells is ultimately piped to a metering and regulation station, and then the gas, once it's measured and the pressure is adjusted, is entered into the Dominion Interstate Transmission Pipeline. One of the key issues is this metering and regulation station, which is not an air contamination source for NACs. And so you'll see here on the slide in terms of the timing of the construction, et cetera. And Penn Future here never appealed any of the permit approvals by the PA-DEP to the Environmental Hearing Board. They decided to wait until construction had been completed on all of the compressor stations and go straight to federal court. And this here is just a schematic just so you can get a sense of the distance. The compressor stations are the small little green circles. The Dominion metering station is the red triangle sort of to the bottom right-hand corner to some degree, and then you can see the Dominion pipeline, et cetera, going through there. So as I said, Penn Future filed their lawsuit. They did it under Section 304 of the Clean Air Act, and they advised alleged violations of the Clean Air Act, the Pennsylvania SIP, Pennsylvania's New Source Review regulations, all for failure to obtain a New Source Review permit to construct. They argued that their networks of wells, pipelines, and compressor stations in the Marshlands Play were a single NOx emitting source, and they should have been aggregated. They looked to EPA letter from 1999 that they should be deemed contiguous and adjacent. So the first thing that happened was Ultra Resources filed a motion to dismiss. And basically, they argued that the court lacked subject matter jurisdiction and also that the court needed to abstain. The court does deny the motion, even though it did seem concerned with the way that Penn Future had decided to go here. And the court notes that, plaintiff went ahead and filed in federal district court after Ultra constructed its facilities. And so they considered the argument that they had forfeited their right to seek judicial redress by not appealing through the Environmental Hearing Board. But the court goes on to find clear language in the Clean Air Act to allow them to bring this lawsuit. And so they expressly allow it to go through. And the court decides not to abstain, and that's a complicated legal issue, but they didn't find sufficient reason for the court not to take a position. So they deny the motion to dismiss. Their Pennsylvania DEP did file briefs on the motion to dismiss, but they do not go forward. As you'll see, Ultra Resources has now also filed a motion for summary judgment after fact discovery, and Pennsylvania DEP has not participated in that motion. So Ultra Motion went forward and filed their motion to dismiss, and they've argued, first of all, looking to Summit, that contiguous or adjacent doesn't include operational interdependence. They cite Pennsylvania DEP guidance. They look to the plain language of the regulations in terms of contiguous and adjacent, and they say it just doesn't include operational interdependence. They argue in the alternative, but even if it does, here, factually, these facilities don't even meet that definition. The fact that each compressor station is tied into an M&R station doesn't make them functionally related. It argues that Penn Future really doesn't understand how the facilities work. It also argues that an M&R station, which is not in and of itself a NOx-emitting source, can't be the way that NOx-emitting sources are aggregated. So that can't be what ties them together and makes them interdependent. And then finally, Ultra Resources argues that Penn Future's definition, which is fairly expansive as to what adjacent is, would really be contrary to public policy and interfere with what Pennsylvania DEP policy says. And particularly given the fact that Pennsylvania DEP is not a party to this case, Ultra Resources takes significant argument as to why the court should not go ahead and overrule their determination in this case. Not surprising, Penn Future has opposed Ultra Resources' motion. It first argues there's disputed issues of fact in terms of distances between the facilities, etc. It also argues that Summit is distinguishable because here the marshlands play is 13 square miles less than the geographic distance being addressed in the Summit decision, where there the court didn't say, oh, that's too much. It remanded for a determination. So their argument is, well, the distance is less here, and so therefore Summit is somehow distinguishable. It also argues that functional interdependency is not an alternative to proximity. It's just an additional factor to consider. And it talks about this idea that you can't consider proximity in a vacuum. You need to look at it in terms of context. And it actually argues that that's what the dissent understood in Summit, and that the majority there apparently did not. And that when you're looking at what is physical approximate, you need to consider other factors besides those of just linear distance, and that there's no built-in ruler. And so what is close and proximate for one issue, i.e., how close is the store to go pick up milk, is different than how close it would be to travel to visit, your favorite grandmother or something. So they really try to introduce this concept of context becomes very important instead of just what is the geographic distance, because a quarter of a mile in one situation means something different than it does in another situation. And then finally, it does argue that the reason that they are interrelated here is because all of the gas comes through this metering and regulation station before going into the interstate pipeline. And then it really does argue that Summit is unworkable. It argues that it's been rejected by both the EPA and the Environmental Hearing Board. It says the EPA rejected it. That's their Summit directive that we talked about earlier. And two, they argue that even the Environmental Hearing Board has rejected it because look at the decision in Mark West that I just spoke about, where the court said that they would consider testimony about functional relationship at the subsequent hearing, even though it never got that far. Oral argument was held back in April. There's still been no decision. Since that time, there have been some additional filings regarding whether or not there really is a dispute of fact that would prevent the court from ruling on summary judgment. Ultra Resources has filed a response. They're not really into disputing the actual accuracy of the distancy, et cetera. They see this really as an issue of law that the court can decide and is willing to stipulate some of the distances. And then finally, just recently, Ultra Resources did file a notice of supplemental authority, letting the court in 10 future know that the needed decision had come down from the short circuit. It's a very, very short filing. It's only a couple of pages, and I put in a quote here of what was included in that notice. And it's really just to let the court know that the D.C. Circuit has held that EPA's directive is no longer valid. So outside of court, we have a couple of Environmental Hearing Board cases that are pending right now in Pennsylvania dealing with National Fuel Gas and Seneca Resources. And so I'm just going to go through quickly some of those cases to give you a feel for what the Environmental Hearing Board is looking at. And all of these are appeals by either National Fuel Gas Midstream or Seneca Resources. So in the Tenesta station, and I hope I'm saying that correctly, the DEP had to consider whether to aggregate emissions from Seneca's compressor station and National Fuel Gas Midstream's interconnect facility. And the DEP actually concluded that the two facilities were a single source. And here, even though the DEP found that there were SIC code differential, so we didn't establish that first criteria for aggregation, it found this existence of a support relationship, and you'll see that theme throughout these three Environmental Hearing Board decisions. And so that, in and of itself, is enough to override any difference in SIC codes. Here, they also found that the facilities were on, quote, one property. They were about 200 to 300 feet apart. And then again, the support relationship to establish common control. Even though the agreements between Seneca and National Fuel Gas Midstream didn't meet the SEC's definition of control, here the DEP disagreed and found because they had this support relationship and contractual financial agreements, they did have common control. And finally, they decided that these two facilities together created a single common product, and that was sufficient to meet the common sense notion of a plant. Seneca Resources appealed to the Environmental Hearing Board. They argued that the sources don't have a support relationship, which is evidenced by the fact that they have different SIC codes, and also by the looking at their methods of operation. The facts don't establish a support relationship. They also argued that they don't function together to meet this, quote, common sense notion of a plant, and that the DEP's determinations about common control was arbitrary, capricious, abusive discussion, etc. And really, Seneca Resources was concerned about what this precedential impact would be over other aggregation determinations, not just for them and national fuel gas companies, but across Pennsylvania for other entities. And then, not surprisingly, National Fuel Gas Midstream petitioned to intervene. They're making the same exact arguments as Seneca Resources. And so that petition to intervene was granted in September, and we're still waiting for the Environmental Hearing Board to move forward on that case. Here's another one with two other National Fuel Gas and Seneca Resources facilities. Here we've got the Pad G station, Seneca Resources well pad, and then National Fuel Gas Midstream's interconnect facility. Once again, DEP concluded that the two facilities were a single source. They found the existence of a support relationship again. They found that the facilities were on one property. Here, those properties are in separate counties and are separated by over a mile. They found the support relationship because of the contractual and financial relationships as well. And then the two of them together, they met that common control requirement. And further, they found this common sense notion of a plant by the two facilities. Appeals were filed separately here by National Fuel Gas and Seneca Resources, objecting to almost all of DEP's arguments. Once again, the same arguments we saw in the prior case. They argue there was no support relationship. Methods of operation did not support that. They argued that it was improper for DEP just to look at simple surface right ownership. These facilities were dispersed over areas encompassing many square miles. They looked to the guidance from the DEP, where a quarter-mile rule of thumb for determining adjacency, and pointed out that here it was over a mile. and they continued with the common sense notion of a plant, etc. Those cases were consolidated in May, and we're waiting for another case, or a decision from the EHB to go through. And I'll just note that the DEP's determination in these cases are very, very short and sweet in terms of how they summarize these arguments when they provide them to the operators. And then the third one is the Bodine compressor station, where here DEP decided to combine some sources. And so what were they looking at? They were looking at National Fuel Gas's proposal to construct the Bodine compressor station that was going to receive natural gas from two of Seneca's well pads, well pad E and well pad M. And currently, both of those well pads were conveying gas to a separate compressor station, the Hagerman station. So well pad E was about 0.24 miles, keep in mind that quarter-mile rule of thumb, from the proposed compressor station. And both the Bodine compressor station and well pad E were going to be located on the same state forest land, and there was no physical boundary between the sites. Now, all other sources, including the well pad M, the second well pad, and the Hagerman compressor station, were going to be greater than 2 miles away from the proposed Bodine compressor station. So DEP sort of split the aggregation determination here. So it decided to aggregate the compressor station with well pad E. No other sources were to be aggregated, so not well pad M or the other compressor station. And here it found an existence of a support relationship because the gas would be conveyed, dehydrated, and metered at the compressor station. And it really rejected the argument that gas from well pad E could go to a different compressor station because it saw from the application materials the real intent here was for a Bodine compressor station to be used. It noted that there was different SIC codes, although it talked about historically these types of activities belong to the same SIC code. And once again, we find the support relationship concept coming in to override any difference that may be there. They found common control because Seneca Resources and National Fuel Gas Midstream are owned by National Fuel. They also looked at the contractual agreement. And then, as I said, the quarter-mile distance and the lack of any physical boundaries between the two, as well as being on the same land, is what they focused on for the adjacency requirement. So National Fuel Gas has appealed. They've argued basically all the same things that we've seen in the other three cases before this one. Seneca Resources was allowed to intervene, and we're waiting for a decision to come down in that case. It's been some time. So that's it for Pennsylvania on where we're at now. Clearly, the big thing right now is waiting for the Penn Future case to come down. It'd be interesting to see whether or not Penn Future is going to file in a response to the supplemental authority about the needed decision, but time will tell. So let's move on to West Virginia. West Virginia doesn't have a separate aggregation guidance document like we have in Pennsylvania, but they do have a discussion about aggregation in their application instructions. And there, it's fairly short. It's a little bit more than a page where they lay out the entire aggregation discussion. But they recite the three-pronged test that we talking about for the last hour in terms of the SIC codes, common control, and contiguous or adjacent properties. They also note that this is a case-by-case determination that would vary based on the facts of each case. And in terms of the third criteria, the one that's the most important, contiguous or adjacent, or at least the most controversial, it does recite dictionary definitions, as we've seen in Pennsylvania. It talks about what does it mean to be contiguous, what does it mean to be adjacent. It notes that they are proximity-based, but it doesn't define a distance. You don't get a rule of thumb in West Virginia in terms of what would be presumed to be adjacent or not. It continues through with saying all determinations will be case by case, but that we're going to focus on proximity and, of course, remember the common sense notion of a plan. And that, as we've been told by the courts, we have to avoid aggregating facilities and activities that don't fit within that ordinary definition of building, structure, facility, or installation. And then we've had a few administrative decisions in West Virginia addressing this issue. So the first one is Appalachian Midstream Services, and as you'll see, this one's a couple years old. And there, the Division of Air Quality issued separate permits for the construction of two compressor stations. They were located over 3 miles apart, and but they were connected by pipeline, and there were about 25 well pads in that field, although none of them were contiguous with either of the two compressor stations. And the Division of Air Quality decided that neither was a major source and that they were separate, and that there was no need to aggregate with any of the well pads. Well, the Group Against Smog and Pollution filed an appeal with the West Virginia Air Quality Board, and there the Air Quality Board applied a case-by-case determination. And they found that the oil and gas field at issue didn't fit the common sense notion of a plant, and they upheld the department's decision not to aggregate in that case. Interestingly, there they had started to have an evidentiary hearing, but at the end of one day, the Air Quality Board went ahead and upheld what the DEP had done and dismissed the appeal. The next is Stone Energy Corporation in terms of their well pad 3. And there the DEP considered whether or not they were going to aggregate emissions for a well pad that had 8 wells. Following the 3-way separations, the gas was going to be routed into a gathering line that was owned by others, and then would ultimately go through Stone Energy's compressor station. So here we sort of have a split in the aggregation. So DEP did aggregate the emissions from the well pad, all the wells on site, and the associated equipment. Had the same SIC code, common owner, and they were located on contiguous property. Even with that aggregation, it still wasn't sufficient for them to be a major source for purposes of permitting. The DEP did decide there was no aggregation with any other well pads, though, because no gas in the other wells would be routed to or away from this new well pad. And finally, there wasn't going to be any aggregation with the receiving compressor station. Even though same SIC code, you had different ownership, and the facilities were over 2 miles apart. Another one is Williams Ohio Valley Midstream, their dehydration facility. Their DEP applied a case-by-case evaluation, noted that these decisions are proximity-based, looked to the dictionary definition of adjacent, and you'll see some quotes here that you'll see in the determination, not distant, nearby, having a common endpoint or border, and ultimately DEP declined to aggregate. Even though they found that the wells were in close proximity, it wasn't necessary that this dehydration facility be in the immediate vicinity of the production. It was put there for other reasons, and therefore, because it could be moved, aggregation of the wells didn't meet that common sense notion of a plant. And finally, most recently, from May of this year, the Pinecone Compressor Station. Here we had a decision about whether or not to aggregate emissions from a compressor station in local production wells. And the DEP applied a case-by-case evaluation and declined to aggregate. Even though you had the same industrial grouping, they found no common control, but that the facilities, and also that the facilities were not contiguous or adjacent. The closest other facility owned by Williams was at least a half a mile away from was over 2 miles away. All the other facilities were at least a half a mile away. So once again, did not meet that common sense notion of a plant. And that's really it for where we are in West Virginia. Now, New York, I'm going to go through a little bit quickly. As everybody knows, we're not drilling in New York. But New York doesn't have a written formal policy or guidance to address this issue. The only thing that exists in New York today is throughout this long, almost 6-year environmental review process where we're trying to get to a final supplemental generic environmental impact statement. DEC does address aggregation with respect to the oil and gas industry. I'll just say the last draft we've seen of this is from 2011. I believe September 2011. There's been no drafts at all since that time that have come out to the public to see. So it's still a work in progress. There has been a significant number of commenting from both environmental groups and industry. So if and when we do get to a final, anything we've seen or I'm going to talk about in the next few slides are likely to change just because there's been a significant amount of time, a significant amount of comments, and we've had such an evolution of the issue in other jurisdictions and from case law. So where do we find New York's proposed guidance? It would be Appendix 18 of the revised draft of the Supplemental Generic Environmental Impact Statements. So it does cite primarily to EPA determinations and guidance, although it cites to one Colorado order. It was released prior to the Sixth Circuit Summit decision. It does cite to the EPA's underlying decision in Summit as part of the rationale for its determination. And the DEC and its guidance notes that there's been no specific distance to establish whether or not two facilities are adjacent. It recognizes, interestingly, that interdependence is not part of the definitions, and that in the context of oil and gas infrastructure, it probably has reduced relevance. However, to be thorough, DEC is going to evaluate functional relatedness between facilities and look at the degree of interdependence when they're deciding whether or not sources should be aggregated. And you'll see here they do cite the EPA's 2010 summit determination. And so this is just a few more pieces from Appendix 18 in terms of what DEC is going to look at. Some of their questions, they don't always make sense here, but these are just a few that we pulled. So where is New York right now? You know, it's unclear what's going to happen. I can tell you when the first summit decision came down from the Sixth Circuit, industry wrote a letter to DEP asking them to relook at it. I know that it's been part of the comments. I'm sure they've been looking at what's been happening. So we're just going to have to wait and see, one, if New York moves forward, and hopefully it will after the election this year, and two, when it does, how they decide to revisit their aggregation draft. So I know we're getting close to the end of this, and so I just put up here towards the end sort of a hypothetical to sort of highlight for people how complicated some of these issues can be. And so you'll see we've proposed a few different well pads, a processing plant, you've got an interstate pipeline, et cetera, crossing state lines in terms of how two states may look at something and whether or not sources should be aggregated or not. And then this just shows you the distances going anywhere from 1/4 of a mile, which is the rule of thumb in Pennsylvania, to almost a mile apart, and whether or not you're dealing with one region of EPA or the New York DEC or the Pennsylvania DEP. So it really just highlights, given everything we talked about today, how complicated these issues may be in terms of, you know, DEP may not want to aggregate sources, but DEC may have a different view, et cetera, and the complications that we're going to get as states begin to evolve over this issue, where the courts are going to come out in Penn Future, for example, and how these determinations are going to be made going forward. So conclusion, what is the current state of the law? U.S. EPA right now is constrained. It has to follow Summit. It has to look to geographic proximity, not to functional relatedness when it's making single source determinations. That's all subject to change depending on how they react to the recent needed decision, whether or not they petition for cert, go for a rehearing, et cetera, or if they decide to take the longer view towards a new rulemaking, and whether or not that would even withstand legal muster. In Ohio, I didn't talk about it in detail, but Ohio is in the Sixth Circuit. It is governed by Summit. It follows Summit. There's very little at the administrative level on aggregation, perhaps because of where the industry is in Ohio. It just doesn't seem to have come up yet. That doesn't mean it won't, but right now, Summit should be the rule in Ohio. Pennsylvania, you've got the 1/4 mile distance rule of thumb. We're still waiting for the Penn Future case to come down, talk about functional relatedness, et cetera. But under the Pennsylvania guidance document, you do have that case-by-case determination if it's greater than 1/4 mile apart. West Virginia, no defined distance at all, and you do have that case-by-case determination going through. And you saw from the cases that I went over before, most of their permitting decisions are not aggregating, except for in rare circumstances. In that one circumstance, it wasn't enough to even get them over the threshold. And finally, in New York, we don't have a formal policy statement, and it's likely that draft that we have out is likely to be reconsidered, and hopefully would be reconsidered by the DEC before moving forward. So that's it. I'm going to open up my screen to see if any of you guys have any questions, but we're just a few minutes before 2 o'clock. So if anyone has any questions, feel free to type them up. Otherwise, we'll conclude. And if anyone has any questions later on, my contact information is on this presentation as well, and I'm happy to take them. You can either give me a call or email me. All right, well, I'm not seeing any questions, so I'm going to go ahead and close the webinar. I thank everybody for joining us this afternoon. And once again, if you have any questions, feel free to reach out to us. We'd be more than happy to help you. Thanks, and have a great afternoon.